Good evening. Welcome to Lawyers on the Line. I'm Jim Peterson, a partner with the Duluth firm of Falsani, Balmer, Peterson, Quinn, and Beyer, and this evening's moderator. Tonight's topic is legal ethics. According to a recent article in the Minneapolis Star-Tribune, 20 Minnesota attorneys have been disbarred, suspended, publicly reprimanded, or placed on probation so far this year, which is a big spike in the number of lawyers cited. So much so that total disciplinary actions for 2013 is likely to surpass last year's total of 38 and might beat the record of 55 lawyers sanctioned in 1990. So tonight's topic is legal ethics. What are the rules? Who enforces them? I'm pleased to welcome our panelists who will take your questions about tonight's topic. Megan Engelhardt, Assistant Director with the Minnesota Office of Lawyers' Professional Responsibility. Sean Quinn, partner with the Falsani Balmer firm, and Terry Trogdon of the Gerlach, Beaumier, and Trogdon law firm. Megan, Sean, and Terry will answer your questions about legal ethics. Please call with your questions at 218-788-2844, or if it's long distance for you, you can call toll-free at 877-307-8762. First of all, before we get to specific questions, maybe a little background. What do we mean by legal ethics? What is it? Where did it come from? Megan, why don't you start?
Well, legal ethics is something that's started in law school, really. Ideally, the legal profession includes people who are of quality educationally, but also morally and ethically. And the Minnesota Supreme Court has issued rules of ethics that attorneys need to follow, and there are several. It's a large section, and it includes everything from a duty to communicate with your client to a duty to tell the truth in representing a client. So our office is in charge of enforcing and investigating complaints against attorneys. So it definitely has been an uptick in public discipline so far this year. But as the article did talk about in the Star-Tribune, that really does ebb and flow through years. Some years are heavy, some years are higher. There isn't really an exact science as to why it may be higher this particular year, but it certainly is possible for us to have the most since quite a few years.
Just to put it in perspective, we're talking about a record of 55 public disciplines in a year. How many lawyers are licensed in Minnesota?
I believe there are about 26,000 attorneys licensed in Minnesota, so it's a very small portion, which is impressive, I think, overall for the legal community. I think attorneys truly do take ethics very seriously and want to do things properly and appropriately, and that's nice to see.
Sean, you've got a visual aid, which are
Sure.
the rules, right?
The rules. These are the ethical rules. That's all this book is.
And they've, as Megan already said, cover a range of both duties that lawyers have to follow and things that they can't do.
Right.
How do the rules get enforced?
Well, the rules are, in a sense, self-enforced. All lawyers agree to abide by them when they take their oath and they're sworn in. But if a lawyer is alleged to have violated one by another lawyer or by a client or, frankly, anybody, then the complaint gets sent to Megan's office. They do an initial investigation. If they think that there might be some merit to this, then they typically send the investigation to the community where the lawyer lives. Up here in the Duluth area, we have a local ethics committee that I'm on, Terry is on, you used to be on, and we all do the investigations and make ultimately a recommendation after the committee discusses the investigation, and then at the end, Megan's office ultimately makes the final determination.
So Terry, if you, and we're kind of talking in generalities here, if you're on the committee and you get assigned a complaint by a client against a local lawyer, what do you do?
Well, the first thing that happens is I get a letter and the complaint from the chair of the committee, and that a person is chair for 6 to 8 years, usually. When I get that, I send a copy of it immediately to the attorney about whom the complaint is, and that attorney has the duty then to respond to me in writing with some sort of response specific to that complaint. I take that response, send it to the complainant, the person complaining, and ask them to follow up with me in writing. I usually then talk with that complainant on the phone. I will talk with the attorney on the phone. If there are any other individuals who've been affected by the activity or who may have information about whether it's true or not, I call them, make a file. It's documented with contacts, with any documents I may get, make a report following a particular format, bring it to our committee. We make a recommendation to the board in St. Paul, and the entire file that I have gets put, it leaves my office. It's totally confidential to anyone else in my office. My partners don't see this, and it goes in its entirety to the chair, who then is basically the safe keeper of that information.
And the Ethics Committee, not only here, but throughout the state, has not only lawyer members, but also non-lawyer members, right?
That's correct. On our board right now, on our committee, there's a university professor, there is an intern who is going to be a law student, and there is a paralegal from a firm. We're always looking for people who are interested to be on the board who are not lawyers. It's an important component.
And one thing that, maybe Sean, you'll know this.
All right.
It's a quiz.
Oh, great.
Aside from specific rule violations, what is the most common reason that clients become disgruntled with their lawyer and want to make a complaint?
Oh, I guess I don't know from a statistics viewpoint, and Megan probably does, but I assume it has to be failure to return phone calls. Absolutely.
Communication, is that right, Megan?
Absolutely.
I knew you knew, so I asked him.
Yeah.
Absolutely. I would estimate that about 80% of our complaints involve some aspect of communications. Either they feel the attorney didn't adequately communicate with them about their case or didn't return their phone calls. That's a very common complaint that our office sees.
And is that covered by a rule?
It is. It's covered by Rule 1.4.
There's a test
All right.
for the audience.
Yeah.
Yeah. Okay, some specific questions. I guess I'll go back to you, Megan. My lawyer plays golf with the other lawyer in the case, I guess on the other side. Isn't this a conflict of interest?
Well, I can certainly understand why someone would feel that it might be a conflict of interest, but it's not. Unfortunately, to people that are not in the legal profession, it sometimes does seem unnerving to see the opposing party socialize with your attorney. And I think that's a natural. Ideally, your attorney is going to bat for you, and to most clients, they consider that to be kind of a case of war almost, and it's almost like fraternizing with the enemy, that you would be having a golf outing with the opposing party. But it isn't, and actually it's probably very common. Attorneys become friends and socialize. Maybe they went to law school together, so it's very common that does happen. But it certainly isn't a conflict in violation of the rules.
Sean, generally, what is a conflict under the rules? I know it's complicated, but...
It is complicated, but in general, a conflict is when your representation of your client has some sort of adverse impact on another client. So if I'm representing, I do car accident litigation. Two cars run into each other. I can't represent one party against one for the car accident and then the other party against the other for the car accident. If the interests of my client are adverse to somebody who would be a prospective client, then that's where the conflict is. It's not just, as Megan alluded to, it's not just because I happen to socialize with the other lawyer. It's because I can't represent the other party, but I can certainly socialize with that party's lawyer.
There's one other component to that that's a little more subtle, and that is when you get information from your client and it's something that could be adverse to a different client, you then have a conflict of interest and may have to withdraw from representing either client. So it can get pretty tricky sometimes trying to figure out what is adverse and what isn't.
Terry, what if a married couple comes to you and says, you know, we want to get divorced, we got everything worked out, we don't want to pay 2 lawyers, can you just do it?
I bet I get a call like that once a week. And the answer is, I can do it, but I'm not going to do it representing both of you. I will represent one of you and make it very clear to the other that I am only representing that one. We can work as a team to try to come up with an agreement, but the person that I am not representing is fully informed that they have every right to have some sort of representation at any point, beginning, middle, or end. And if they waive that, I actually get a written waiver that's filed with the court to show that they understood and they were provided with that information.
It's a question from a viewer. If my lawyer gets suspended, what are my options? Can I hire a new lawyer or a new firm? Megan.
If your lawyer is suspended, you can hire a new lawyer, absolutely. Obviously, it's unfortunate when your lawyer gets suspended while you're representing, when they're representing you, but they can't continue to represent you even though that might cause an inconvenience to you. So you should be able to get another attorney. Sometimes they'll refer you to someone, but if you're uncomfortable with that, you can always get another attorney.
In fact, you can get another attorney whether your lawyer is suspended or not, right?
Absolutely. A client can always decide that they want to end the representation agreement.
Here's a question, and I'm going to rephrase it a little bit. The question has to do with some lawyers practicing only in select counties within, say, the state of Minnesota rather than statewide. I guess it has to do a little bit with, you know, your license, Sean. Does your license limit you geographically?
Oh, no. My license is good in the state of Minnesota. But in that sense, it's geographically limited. I cannot practice in Douglas County unless I was admitted in Wisconsin. Many lawyers in Duluth are, but I'm not, and so I cannot practice in Douglas County. But I'm certainly free to practice in any county in the state of Minnesota. The license that a lawyer gets is issued by the state Supreme Court, so it's good for the entire state.
That actually gets to be an issue sometimes. I'm licensed in both Minnesota and Wisconsin, and that's not a real common thing, surprisingly, as close as we are to the border. But it's very difficult sometimes for people to understand which state actually has jurisdiction. And because Sean is only licensed in Minnesota, he can't even render an opinion as to whether Wisconsin has jurisdiction over an issue. So it's something that county by county is not limited, but going over that state line makes a big difference.
Here's another question. And it brings in social media.
Ooh, always a hot topic.
My lawyer's paralegal is Facebook friends with my soon-to-be ex-spouse and with me. Is this a conflict of interest?
Ooh.
That's a very good question. I don't necessarily think that is going to make a conflict. Obviously, if the client is uncomfortable with it, the client could choose to un-Facebook friend the paralegal for a period of time, and that probably would be something that her attorney, and Terry, maybe you would know this because you practice in family law, you would probably recommend that they not be Facebook friends while the case is pending.
It's true that gets to be a sticky situation. But with privacy settings and things like that, people can really control that. It is not a violation of the rule as far as we've determined, and we have actually had situations like this at our firm, so we've done the analysis. But the paralegal must not engage with, under what we've told our paralegals, don't engage with that person. If you want to, if she or he is posting on their account and you're looking at that, that's fine. It's being posted to a lot of people. But you cannot, paralegal cannot go in then to messaging and ask questions. They cannot go and, as a representative, even marginally of the attorney, go in and interact with that person about anything even remotely related to the issue.
Wasn't there a case recently where somebody had their paralegal pretend to be a friend with somebody in the middle of litigation, and then that created a whole series of problems?
There was a situation
Yeah.
like that where the attorney was handling, I think it was a personal injury matter, and had wanted to find out what the plaintiff was doing and had asked his paralegal to become Facebook friends with her. The paralegal didn't know the plaintiff at all, and just sent a friend request, and we did determine that that was a violation of the rules. Because it would be no different than having the plaintiff was represented, which
Right.
makes a big difference. And the paralegal, it would be like picking up the phone and calling the plaintiff. So the attorney was disciplined for that. It was private discipline, but still.
Terry, I'll send this one to you because it involves family law. The question is, I called my son's divorce lawyer to find out why he has to pay his ex-wife's bill, and she won't tell me. The lawyer won't tell the mom. Can she do this?
Absolutely. In fact, she must do that. There's the confidentiality. There's confidentiality and there's privilege. Privilege is something that is dealt with in the courts. Confidentiality means that a lawyer keeps all information that they get from a client, even if it's on a public page someplace. They don't discuss it, they don't share it. Somebody can call and ask for information. They are not to provide it unless the client gives them permission to do so, or it will more than just slightly advance their cause, that there's a good reason for it. In a situation like this, it has nothing to do with advancing the cause, is not involved in, hasn't gotten permission, and that attorney is obligated to not provide that information, can only discuss it with the client.
Okay, follow-up. What if the mom is paying the bill?
That's nice of her.
The
That's it.
answer's the same.
Yeah.
And in fact, the attorney should have had a conversation with the mom and the client at that time, and at the time that they said that they were going to make this agreement, to explain to the mom at that time, this information is only going to be to the client. You are not my client. Client will be the only one who I can discuss things, and client needs to approve the arrangement and give their informed consent to this.
Sean, question about fees. At what point does a lawyer's amount of the fee, or how it's being charged, or how it's handled within the finances, at what point does that become an ethical concern?
Well, it's always an ethical concern because the ethical rules make it very clear that fees must be reasonable. And then the rules define what that means. It depends upon the nature of the matter that the lawyer is representing them on, the lawyer's skill, how much effort is required. So the fees always have to be within ethical rules, and that means reasonable. So it's always at issue. And separate and apart from ethical issues, there can be disputes about fees where there isn't necessarily an ethical violation, but there can be a fee dispute, and there's actually a separate system that can resolve that potentially if both parties are willing to.
What about how a fee is handled within the law firm? In other words, if someone comes in and pays a $10,000 retainer for a divorce proceeding, how is that money supposed to be handled?
Well, typically, in a typical case like that, where that would normally be an hourly fee type of thing, the money, the $10,000, is the client's money. It's put into a trust account. Lawyers are required to keep two separate accounts. One account is the lawyer's account, where that lawyer or that law firm's money is, and the other account is the trust account. Those are the client's monies. And the money sits there, and then this will be laid out in the fee arrangement usually. The lawyer will bill the client monthly or however regularly they agree to, and say, this is how many hours I put in, this is the hourly rate that we agreed to. I'm drawing that amount of money now out of the trust account and putting it into my general account. And so that's generally how it works.
Here's kind of a broad question, Megan. Can a lawyer lie while representing a client?
No. The short answer is no. A lawyer cannot tell a lie while representing a client. And obviously that's the key. Obviously, when I go home at night and my husband asks me, did you do this today? I can lie to him because I'm not representing a client. And that's a key, an important part. Otherwise, it would be very hard to be a lawyer and not be able to say, no, those pants look great. So it definitely is something, yeah. But while representing a client, a lawyer has to tell the truth to the client and to the opposing party. And that's definitely a difficult part. Because clients sometimes do want lawyers to lie for them, and lawyers cannot. And I think probably from my office's perspective, oftentimes what we see is attorneys who maybe didn't work as quickly as the client wanted them to work on the file, and maybe weren't completely diligent on it. And when the client calls and asks about it, as clients often do, the lawyer says, "Oh, I've done it. It's at the courthouse." That's a lie, and because it isn't at the courthouse, it's sitting at. He hasn't filed the paperwork, and that lie has now made it a much more serious offense and is going to be possibly resulting in public discipline, whereas just not working on the file, while frustrating to the client, would probably be something more like private discipline. So it is something our office takes seriously.
But what if you call the lawyer to ask about lying to the client, and then they lie to you?
The client lies to you?
No, the lawyer lies to you
During the investigation?
while you're investigating the lie in the first place.
Oh, well, then they're definitely going to get in trouble. And that does happen, unfortunately. I think that age-old thing that you tell to a child that, the lie is always worse than the crime definitely applies to lawyers, and unfortunately we see that over and over again, that they'd be better off if they just told the truth from day one.
Sean, the other side of the lying issue, what are our lawyer's responsibilities when he has reason to believe that a client either has lied or wants to lie, is planning to lie?
Well, a lawyer is never allowed to put a client, say, on a witness stand to testify, knowing that the client is going to, lie. And the situation that arises in most often is in a criminal defense situation. And so you can't have, question, answer between the lawyer and the client where the lie just keeps going and going and going. And because a criminal defendant always has a right to speak in his or her own defense, however, what the lawyer can do is put the client on the stand and say, go ahead, tell your story, or something like that. And that means the prosecutor knows what's going on, and the judge knows what's going on. The jury might not know what's going on, but everyone else in the room does.
What if you have a client in a personal injury case, and the client testifies that he's seen 27 different doctors for this injury, and you know that it's only been 4, and testifies that he can only lift 10 pounds at a time, and you've seen him lift a 20-pound briefcase? What do you do then?
That is a very difficult scenario. Pass. No. In a situation like that, fortunately it doesn't happen too often. What you can do, and what the best course of action I think to do, is you take a recess, take a break, you go talk to your client, and you say, look, you've said some things, it just doesn't comport with the record. I'm going to put you back on the record. I want you to tell the truth, and I'll ask you, what was going on, and you can, tell the court or the judge or the jury that you were nervous, you were scared, you were afraid that people weren't going to believe you unless you, exaggerated. But then tell the truth, and you'll look so much better by being honest.
Terry, kind of a nuts and bolts question. If someone out there has a problem with their lawyer and is listening and thinks, gee, maybe my lawyer's violated one of these rules, what are the options?
Well, one of the things that they can do is they can call the board, the Office of Lawyer's Professional Responsibility, and ask for some guidance. They can get access to the rules. They can read through them. They can also call another lawyer who may be willing to discuss it with them or may not. But ultimately, if they really think that they've been wronged in an ethical sense, not just in a malpractice sense, and that's very different, then they should be filing a complaint, and it will be investigated. All complaints are investigated if they go through the initial screening with the office. And once the ball is started rolling, the investigation just doesn't include what the complainant initially said. It includes anything else that is uncovered during that investigation.
I do just want to quickly say not all complaints are investigated.
Are they all screened?
Well, they're at least screened.
They're screened.
Okay.
Because we do receive about 1,400 complaints a year. So we do screen some out. And some are dismissed because we can't investigate them. It might be there's a criminal matter pending and we want the court to make a determination in that matter. There's various reasons. So they do, if you file a complaint, which I strongly encourage anyone to file a complaint if they have a concern, there is a screening, but it might not necessarily get investigated in the way that Terry spoke about earlier, where she gets a response from the attorney.
We're almost out of time. Quick answer. Does a lawyer who is suspended or disciplined have to tell his or her clients?
Absolutely.
What
He
if-
is required under rules. He or she is required to do that.
And what if he or she doesn't?
Then I would hope that the client would inform our office that that was not done so that we can take proper measures.
That could be another violation in itself, I imagine.
It could be.
All right, I think we're out of time. Thank you very much, Megan and Sean and Terry. Good discussion. And that's all the time we have. We did want to let you know that you can have questions answered on tonight's topic or any legal topic, answered every Wednesday at noon at the St. Louis County Courthouse through the Volunteer Attorney Program's Ask an Attorney service. It's every Wednesday afternoon. Call 723-4005 to make an appointment. You get 10 to 20 minutes one-on-one with a local volunteer attorney who will be able to answer your questions, hopefully, and lead you on the right path to find the additional legal help you may need. The program is free and available to the public regardless of need. Remember, you can watch tonight's program again online at wdse.org or on the Falsani, Balmer, Peterson, Quinn, and Beyer website. Please join us again next week when we answer your questions about gun violence and the Second Amendment. Nice. I'd like to thank our panelists for their expertise this evening, and thank you very much for watching. I'm Jim Peterson. Good night.